Today's video addresses the question of why the title company cannot release the earnest money without signed releases from all parties, except, of course, in the case of a termination during the option period. During the option period, you know that the buyer is allowed to terminate for any reason or no reason. As long as that termination right had been paid for and the buyer terminates it correctly, for example, sends the written notice within the time specified to the seller at the address contractually agreed to under paragraph 21 of the contract, then the earnest money goes to the buyer without a release. Under every other provision of the contract, for the buyer to terminate the contract, there must be a reason. For example, under the buyer's termination under the third-party financing addendum for failure to obtain buyer approval, that reason must exist before the buyer has the right to terminate. What if the buyer sends a termination using that reason and the seller checks with the lender about the status of financing approval, as he has the right to do under paragraph E1 of the addendum, yet the seller finds out that the buyer didn't even really apply? The reason does not exist and the buyer's not entitled to the earnest money. Whether a valid reason exists or not is not in the escrow agent's right or duty to decide. On the contrary, the escrow agent owes a fiduciary duty to both sides to remain neutral. The parties are the ones who must agree that the reason exists. Any steps taken by the escrow agent that appears to favor one position over another is a breach of that fiduciary duty to the other. Let me tell you a story about how important this fiduciary duty is. We received a copy of a letter from a buyer's agent on one of our files, which was written to the seller. It said the buyer had chosen not to buy the house but knows he's in default. But since he is letting you know early, Mr. Seller, we don't think you're entitled to the full $5,000 in earnest money. We offer to give you $1,000 and the buyer will retain $4,000. Needless to say, the seller refused to accept the compromise. Instead, the seller continued to market the property. When he got ready to sell, we were willing to handle the transaction, although no release in the file, because we had that letter from the buyer's agent acknowledging default. The seller wanted the earnest money and agreed to indemnify us just in case the buyer ever disputed the release of the earnest money to the seller. We had him sign an indemnification, we released the earnest money to the seller, closed the transaction, and went our merry way. About 2 months after the closing, we were served with a lawsuit from the former buyer for a breach of our fiduciary duty for release of the earnest money. We went to the seller under the indemnity, and instead the seller's attorney wrote us back and said, "My client indemnified you only if the buyer made a claim to the earnest money. My client did not indemnify you for a breach of fiduciary duty." I tell you this story to help you understand why the title company cannot release the earnest money without releases from all parties. Thank you for watching my videos. Hope they are of some value. Please let us be a resource for all your closings. Thank you.